Well, hello everyone, and welcome to this event for the Australian Association of Constitutional Law. My name is Associate Professor Alex Deegan, and I will be your chair for the event. I'd like to begin by acknowledging the traditional owners of the country where I am at the moment, which is Moreton Bay, and I acknowledge the Jinabara, Kapi Kapi and Turrbal people as the traditional custodians of that land, and pay respect to their elders past, present and emerging, and acknowledge that these have always been places of teaching and learning. We are very fortunate today to have three speakers with expertise in constitutional law in Brazil, Ethiopia and Israel. And our speakers will discuss constitutional challenges faced in each of those legal systems and consider similarities, differences, and causes of challenges between those different systems. I'll briefly introduce each speaker in turn, and then I will pass over to the speakers to present for 15 minutes each. And I'm sorry, I will have to be very strict due to our time constraints. And then we'll have 10 minutes or so, hopefully, at the end for questions and discussion. So our first speaker will be Dr. Renato Costa, who is a lecturer at the T.C. Burns School of Law at the University of Queensland and an associate editor at the University of Queensland Law Journal. Before joining UQ, Renato practiced as a lawyer in one of Brazil's most prominent law firms, and he specializes in constitutional and comparative law. Renato's paper is entitled Brazil's Federal Constitutions, Can a Leopard Change Its Spots? Our second speaker is Dr. Terafé Ghebreyesus, who is a PhD candidate at the University of Queensland. His PhD examines constitutional approaches to diversity and complexities associated with identity politics and its impact on constitutional design. Terafé was previously a federal judge in Ethiopia. Terafé's paper is entitled Constitutional Instability as a Norm, the Ethiopian Example. Our third speaker is Marcel Schlamovich, who recently completed a Master of Laws at Victoria University. His thesis examined constituent power and the challenge to parliamentary sovereignty in New Zealand, the UK, and Israel. And Marcel's paper is entitled Constituent Power and the Challenge to Parliamentary Sovereignty. Okay, I'll pass on to Renato to start his paper. Thank you, Renato.
Thank you, Alex, for the introduction, and thank you as well to Peter, Sarah, and Adam for organizing the event. It's my pleasure to be a part of this conversation today, as I participated in many of these events by Queensland chapter of the AACL. So thank you for the invitation, and I hope I'll bring some interesting points that warrant further discussion. I've chosen this title for my presentation, Brazil's Federal Constitutions, Can a Leopard Change Its Spots?, in the hope that I'll have time to give you an overview of Brazil's 7 or 8 constitutions, and in doing so, highlight the trends and features that have persisted in all of Brazil's constitutions. I hope to demonstrate how today's biggest challenges in Brazilian constitutional law are not novel, but have been endemically persistent throughout Brazil's constitutional history. In the end, I emphasize 3 main issues I find in Brazil's current constitutional system, and these are the 3 very distinguished spots in this leopard. A high degree of centralism in the executive branch, a lack of constitutional measures against populist or demagogue leaders, and a judicial branch easily swayed by political elites and increasingly involved in political matters. As I said, I do not believe these issues are new or have appeared out of nowhere. Like the spots of a leopard, they have been growing and consolidating through time. So allow me to give you a bird's-eye view of Brazil's constitutions. Brazil was colonized by the Portuguese from 1500 until 1822, when it became independent from Portugal. Brazil's emperor, Pedro I, soon after the independence, called for a constitutional assembly to draft Brazil's first constitution. And after some delay, the constitution was eventually enacted by Pedro I. According to the 1824 constitution, Brazil was a unitary state and a constitutional monarchy. There are 2 points that I think are important to emphasize about Brazil's first constitution. One, that the powers of the emperor were quite extensive. The 1824 constitution created a fourth branch of power called the moderator branch. This branch, whose powers were vested in the emperor, was responsible to moderate the judiciary, legislature, and the executive, making sure no other branch would invade the competences of the other. And the second feature was that the constitution transformed the provinces that had already existed since the colonization period to now become administered by the governors appointed directly by the emperor. So instead of maintaining the political power in the hands of the local leaders, the emperor took away the power and centralized them in himself. The 1824 constitution lasted until 1889, suffering only one constitutional amendment during that period, a constitutional change that abolished the moderator branch and gave more financial autonomy to the provinces. In 1889, a military group from the south of Brazil made a coup d'etat and installed a federal republic in Brazil. Interestingly, and quite opposite to what happened in Australia, there was no participation of the states or the people of the states in making the constitution. In fact, the leaders of the provinces, now to be called states, were informed by the federation by letter. In 1891, this new constitution that came after the coup d'etat, Brazil's second constitution, that constitution was inspired by the United States Constitution. And that became evident even in the name that the framers gave to Brazil, because it was now supposed to be called the United States of Brazil. And if you're wondering how long that name lasted, I can satisfy your curiosity by saying that it lasted until 1988, the current constitution. We will call the United States of Brazil until then. The federal and republican constitution then transformed the old Supreme Court of Justice into the Federal Supreme Court of Brazil, which exists until today as well. And it also attempted to remove the remaining vestiges of centralization in the executive branch by devolving power to local political leaders. As some scholars have commented, however, Brazil did not adopt federalism for the traditional reasons of uniting polities that had previously been sovereign entities, nor as a device to govern different ethnic, linguistic, or religious groups. Instead, the virtually powerless former provinces were simply converted into quasi-sovereign states, first by military fiat and later by the 1891 Constitution. And as a consequence, then, Brazil's second constitutional experiment created this isolated federation because there were few constitutional and practical links between the orders of government. If the first constitution erred in centralizing all powers in the person of the emperor, the second pulverized the power in such a way that no real connections between the states existed. So Brazil was a society accustomed to having one single leader to command from the top down the political life of the community. And although some federalist claims have always existed during the imperial era, Brazil's first federal experience was apparently too radical. So the context was ideal for a charismatic leader to appear. And here we start to see the second endemic problem in Brazil's constitutional system, the one that I mentioned before, which is the facilitation of populism. In 1930, a revolution instigated by supposedly fraudulent elections led to the rise of Getúlio Vargas to the Brazilian presidency. This revolution of 1930 reordered the political institutions and established a centralist, nationalist, and fascist regime in Brazil. Two new constitutions were enacted under Vargas' dictatorial presidency, one in 1934 and another one in 1937. The first one tried to give a cloak of democratic legitimacy to Vargas' revolution, but the second one, however, was a full-on coup d'etat. So on November 10, 1937, and under the pretext of fighting a communist threat, Vargas suspended the 1934 constitution and established a dictatorial rule. In the same day that he suspended the 1934 constitution, Vargas personally imposed a new constitution to the country. Now, I don't want you to lose track here of what I'm saying. So we are now in Brazil's fourth constitution. And here's what we've noticed so far. 3 constitutions were enacted after a coup d'etat, with the first one being enacted after Brazil's independence from Portugal. 3 constitutions established Brazil as a federation, although this last one, the Constitution of 1937, made Brazil a federation in name only, as all powers were concentrated in the federal executive, that is in the person of the dictator. All 4 constitutions had a Supreme Court. However, in at least 2 of them, in 1824 and 1937, the Supreme Court was fully controlled by the executive. As it seems, there are some identifiable spots in this leopard: a high degree of centralism in the federal executive power, a lack of constitutional measures against populist leaders, and a Supreme Court easily swayed by political leaders. Brazil's fifth constitution was enacted on 18 September 1946 after the fall of Vargas' dictatorial regime. The constitution was written by a constituent assembly to reinforce the democratic character of the political institutions, reestablish the separation of powers, and provide a more appropriate balance between the constituent units of the federation and the federal union. And to that effect, references to the president were minimized and previously expanded presidential powers were curtailed. In fact, many consider this Brazil's best constitution, as it managed to regulate expectations and aspirations into a solid and practical document. But can a leopard change its spots? In 1964, during the Cold War, and after some political turbulence that we do not have the time to dive into right now, Brazil experienced yet another coup d'etat. A military dictatorship was installed in 1964, and with it, a new constitution for Brazil was eventually crafted in 1967. If you've been paying attention, you have noticed that this is the third constitution imposed rather than enacted, the fourth constitution resulting from a coup d'etat, the fourth constitution to maintain the federation only in form without granting actual powers and autonomy to the states, and the third constitution to subjugate the federal judiciary and the Supreme Court to the leaders of the regime. The period of the military rule in Brazil is well known for its anti-democratic and oppressive regime, and the fame comes primarily from a constitutional amendment to the 1967 constitution that was called the AI5, the Institutional Act Number 5, which was enacted in 1969. The depth and breadth of this constitutional amendment was tremendous. It changed so much of the constitutional system that it is in fact considered by many as a completely new constitution. The Institutional Act, for example, said the president could now impose a recess on the National Congress, state assemblies, or municipal councils. It could decree intervention in states and municipalities, suspend the political rights of any citizens for a period of 10 years, revoke federal, state, and municipal elective mandates, legislate without any previous constitutional restraints that were enforced in the previous constitution, and otherwise have all acts performed under the AI5 excluded from judicial review. So many consider the AI5 to be Brazil's seventh constitution. But independently of your view, these constitutions of 67 and 69 lasted until 1988. The 1988 constitution is called the Citizens' Constitution because it supposedly rescued that democratic and federal characters of the 1946 and 1891 constitutions. It came to democratize Brazil, allow for ample participation of civil society in the constitution-making process, and reestablish the rule of law and the separation of powers by remodeling the legal and political structures in the country. So, with the current constitution, did this leopard change its spots? I don't think so. Brazil is not the first country that comes to mind when you think of a vibrant democracy, well-balanced separation of powers, stable federation, independent judiciary, or a country without populist leaders or power concentration in the executive. Quite the contrary. Brazil's constitution has changed more than 140 times since 1988 to satisfy different political agendas. There are constant questions about the integrity of our general elections. In the last 10 years alone, we had a presidential impeachment where the Federal Supreme Court decided that the impeachment process should change not to impose on Dilma Rousseff, the president, the penalties associated with the impeachment, that is, to suspend the political rights of the president. The court did not suspend her political rights, despite the express text of the Constitution saying otherwise. And there's more. We have a former president, Lula, who was in prison for over a year for participating in the biggest corruption scandal in Brazil's history, of which 25 billion reais, that's roughly 7 billion Australian dollars, were recovered by the police task force. And yet, he managed to be released from prison by technicalities found by the Federal Supreme Court. which was, by the way, composed of a majority of justices appointed by him and members of his party. We had another president who claimed for the re-establishment of the military regime and even proposed to increase the number of seats in the Federal Supreme Court as an attempt to control the Federal Supreme Court. And after Bolsonaro left the presidency, Brazil experienced an unprecedented event on 8 February 2023, when his followers stormed the National Congress and destroyed the buildings of Parliament and the Supreme Court. We have a justice of the Supreme Court, Alexandre de Moraes, who decided to start investigations, judge, and punish those who criticize the court or members of the judiciary, and who also stood on the same political platform as the president to announce a government policy aligned with the current president's political agenda. In fact, even a former justice of the Supreme Court retired to become the Minister for Justice of the current president. And the list could go on. I could continue here. But Brazil's constitutional system allows for centralization of power in the executive branch, which leads to populist leaders who have such an influence that even the justices of the Supreme Court bow to their will. The current issues that Brazil's constitutional system faces are not new. They are the result of a long tradition of power concentration in the executive, a disregard for a genuine multi-level governance, a popular acceptance of populism without constitutional safeguards, and a Supreme Court that is so immersed in and dominated by the political life of the country that it has long lost its independence. So, if we look at Brazil's history and the current path of the 1988 Constitution and where it's going, it seems evident that the leopard cannot change its spots.
Thank you very much, Renato, for that fascinating discussion of Brazil's transforming, or many, arguably, constitutions. I think there's a lot of questions to ask there, and perfectly within time as well. So well done. All right, we'll move on to Terafe's presentation. Thank you, Terafe.
Thank you very much. I'm trying to share my slide. Can you see it?
Yes, we can see it. Thanks, Terafe.
Yeah. So my presentation is about Ethiopian constitutional history and the Ethiopian constitutional experience, and one may argue that how would that be relevant for constitutional scholars here? The first thing is, as a comparative constitutional endeavor, I would argue that knowing how constitutionalism works elsewhere is one of our job to understand how constitutions are practiced and how what problems those kind of constitutional practices have. The other reason that I'm kind of really entangling with, that I want to share with the audience, is that what would be, as a constitutional law expert, what would be our advice, like maybe for policy reasons, or even for societies like Ethiopia that I'm going to describe, where it's very difficult to maintain constitutionalism and to act according to constitution. What would we say? What kind of advice would we, give to those kind of societies? The same, probably, as a constitutional lawyers, would be, what kind of theories would we come with when some countries' constitutional experience, some societies' constitutional experiences, a little bit different from that of the constitutions of the West, that we know, that of the constitutional experiences based on liberal and Western societies, right? That is what I'm going to talk about. So to kind of give you some background about Ethiopia, Ethiopia is a country that is, like many of you know, but the country located around the Eastern Africa, and Ethiopia. So it's a little bit vast country. It's more than 80 ethnic groups with their own languages live there. it is very multi-ethnic country, and it is also very poor country, economically very poor country. Historically, Ethiopia is Africa's oldest and continuing state, which is basically means many African states were not continuing because of colonialism. Colonialism interrupted many African states, but Ethiopia has never been colonized, like seriously colonized. And also Ethiopian state has been feudal and authoritarian. Throughout its history, Ethiopia, I would say, has never had experienced democratic government. Democratic government and governance is very new to Ethiopia. And these ideas of Western governance are very, very new to Ethiopia. The first written constitution that Ethiopia adopted was in 1931, and Emperor Haile Selassie, I think many generations, older generations know Emperor Haile Selassie, and he introduced the first written constitution basically to cement his power, to legitimize his power. What about the current constitutional system of Ethiopia? The constitution was adopted in 1995. Under the current constitution, the constitution adopted a federal system. It is an ethnic system, which means each state, the majority of the state are ethnically kind of created, which means one ethnic group has its own ethnic state. So the boundaries of each state were created along ethnic lines, And the constitution also granted the right of self-determination, including secession, which means if one ethnic group wants to secede from the country, they can constitutionally do that. They can constitutionally, following certain procedures, secede from the country. The Ethiopian constitution, I would say ideologically, is a very socialist constitution. That is basically, it has the very basic principles of the constitution were socialist and Marxist ideologies. It has like socialist or Marxist understanding of what an ethnic group is. It is typically there are many countries with multiple ethnic groups. Nigeria is one, India is one. Many countries have multiple ethnic groups in themselves. But no constitution in the world, similar to Ethiopia, adopted this kind of understanding of ethnic groups as nations and peoples and the right to self-determination in their constitution. The reason for this is that this is typically kind of copy-pasting of ideas from Marxist to socialist ideas of ethnicity and the right to self-determination. So, like one of the features of socialist constitutionalism is that the constitution is an instrument to achieve one end. Okay. Especially like for socialist constitutions like China is like economic prosperity for the working group, right? So constitution or even rights or like some of the ideas in the constitution are not there by themselves. They are not really valuable by themselves, right? They are an end to something. That end is really like to create some sort of economic prosperity or to create equality for the working class. That type of constitutional ideals are in the constitution. And I would argue that Ethiopian constitution is designed for a single vanguard party to run the country. That is basically, so in many socialist constitutions, they create a vanguard party, which means that what the vanguard party is that it says that the society wants to get somewhere, and the only able and capable party to lead them is some kind of very strong socialist and Marxist party that leads society to that destination. So the Ethiopian constitution is designed in that way to enable the party drafting the constitution to lead Ethiopia to prosperity and equality and all that. Similar to other socialist constitutions like China and previous, even I think now constitution of Vietnam, those socialist-based constitutions. But so the problem, the challenge is that even though the constitution was written, practicing it was very, very difficult for many reasons. Okay, so making the constitution like like leading the written constitution was very difficult for very few reasons that I have put there. The first one is diversity. Some countries are very lucky in a sense that they don't deal with diversity. Okay, some countries are, for different reasons, they are not lucky, which means many different people live together. So I think Stuart Mill thought that it is impossible for divided countries with ethnic and religious diversity to live together and to experience democracy and to experience peaceful government. But regardless of that, Ethiopia is having very difficult problem in managing diversity. And I would argue that the constitution designed today's constitution is the bad constitutional design, because it exacerbates ethnic conflict rather than reducing it. Because it gives each ethnic group, the right to live their diversity, to focus on difference, to focus on who they are rather than what makes them like close to their community. So if you read about politics in Ethiopia, everything is ethnic. Everything that should have been common political problem is now ethnic. And it's almost a very difficult to even just, it's very suffocating even to live in that environment because of what the constitution has created. There's also poverty, and that we know that poverty leads people not to respect the law, to try their fates by just like using violence and force. And poverty is also one of the challenges why the country is not really living up to the constitution. The third one is history. Like Ethiopia has no experience in democratic society, in democratic governance, in rule with reason and compromise and tolerance. So political culture, political power has been always taken by force. In Ethiopian long history, there is only one leader who could live in the country after leaving power. Most of them, they were taken, either they were exiled or they were killed or they went out of their power when something happened to them. So this is a critically an amazing history, and it is very difficult to imagine that such society would quickly come and practice constitutionalism, like reflection, and deliberation. So what can we say? So the problem that I have is with, so when we look the problem that I talked about with modern understanding of constitutionalism. What can we say about that? I think James Madison, I think this is what he said. So he divided society into society that is capable of deciding political life, but with reflection, okay, or and choice, or with accident and force. Some societies are capable of deciding about their politics with reflection and choice. Some societies cannot decide. And I think Ethiopian society, I really have doubts whether Ethiopian society at the moment can decide about their important political life with reflection and choice. And the disagreement talks about what does it mean to have constitution, which is actually basically to have rule of the game and live by that rule of the game, not by power, but by rule of the game, playing politics by rule of the game, just like Olympics, right? Just like Olympics, like the boxing in the Olympics, living political life by following the rules. But I don't think the Ethiopian society is not capable of doing that. So what is the bigger question is, I have two big questions. The first one is practical. Practical is like really, if I think about the society, how it bothers me, how would that society really start to exercise political power, not by violence, but by reason and reflection. The second one for all of us, I think, is theoretical. How would we theorize? How would we scholars theorize experiences like that? And the second one is, what would we recommend such societies, right? What would we recommend such societies? And these are the questions that I want to kind of some reflections on, and I want to leave it with you. Thank you very much.
Thank you, Terefe, for that really interesting discussion about constitutional design and the purpose of the constitution in Ethiopian context. That's really interesting. By the way, if anyone has any questions, feel free to pop them in the chat as well, and we can come to them at the end, or you can, at the end when we have our discussion time, you can feel free to unmute yourselves and ask your question that way. We are running really well on time. Thank you, Renato and Terefe, for being very timely. And so we can move on to our final presentation from Marcel. Thank you, Marcel.
Oh, good evening, and thanks for inviting me along. I'll also try to be as timely as I can. I just want to share a visual aid as well. Just 1 second. Okay, so I've been asked to talk about a very interesting development in Israeli constitutional law that might have relevance in other legal systems as well. Can everyone see my slide there? Oh, I hope you can.
Yes, we can see it.
Okay, good. So I was working over the last year on a master's thesis on a kind of crazy, unhinged project where I was trying to debunk parliamentary sovereignty. So I was looking at 3 countries, the UK, New Zealand, and Israel, which are generally thought to be constitutional democracies governed according to the rule of law. But at the same time, they're said to operate under a system of parliamentary sovereignty, where the legislation passed by Parliament is not susceptible to legal challenge. And I was essentially asking a question, does this make sense? Are these 2 statements compatible, or is one of these facts actually just a legal fiction? And my thesis, well, I don't want to go into it in too much detail, but it was essentially that Parliament is not sovereign, and that Parliament doesn't have the power to radically change the whole basis of the Constitution. and that legislative acts that can't be reconciled with fundamental constitutional principles should be treated as invalid by the courts. And it was all kind of theoretical until partway through my project, the Israeli Supreme Court decided that it agreed with me. And on the 1st of January this year, it handed down a decision which sort of, to a certain extent, vindicated this thesis. So I want to start by giving a little bit of background to Israel's constitutional system. Israel's a unitary parliamentary republic. It's a highly centralized constitutional system. It has a figurehead president. Most of the executive powers held by the prime minister and the cabinet. The legislative branch is called the Knesset. It's a unicameral parliament elected by proportional representation. At the apex of the judiciary, there's the Supreme Court, which when it considers constitutional matters is called the High Court of Justice. And it's composed of quite a lot of judges, 15, but it's also an incredibly busy court, and it needs all 15 of those judges. Israel, like the United Kingdom and New Zealand, doesn't have codified constitution. That is, it doesn't have a single authoritative constitutional text from which all the powers of government can be derived. What it has instead are 13 basic laws, which are often described as quasi-constitutional. Their status as constitutional laws is questionable, although now perhaps less so than it was before. And I'll talk about these in a little bit more detail later. But it's important also to note that the High Court of Justice does have the power of judicial review, both of executive actions and legislative actions, despite there not being a codified constitution. And that's an important difference between Israel and the United Kingdom and New Zealand. Okay, so a little bit of the constitutional history of Israel. The modern state of Israel was founded in 1948 with the Declaration of the Establishment of the State of Israel, which I've put on which I've given you a visual aid there. And that was at that time, Israel was there was a lot of internal conflict between the Jewish and the Arab populations of what had been the British Mandate of Palestine. Even before the Declaration of Independence, the Jewish community had established a provisional administration, but it hadn't been there hadn't been proper elections, and it lacked really any kind of democratic legitimacy. So in the Declaration of Independence, they called for the establishment of a constituent assembly, which would be elected by the people, and it would adopt a constitution by the 1st of October 1948. Now, this turned out to be extremely ambitious because the day after the Declaration of Independence, war broke out between Israel and the neighboring countries, and that war went on for well into the next year. So they never got around to electing the Constituent Assembly. They never got around to drafting the Constitution. Well, they did elect the Constituent Assembly, but not until January the next year. And with the election of that Constituent Assembly, they dissolved the Provisional Administration. So the first act of this Constituent Assembly was to declare that it would have two roles. It would act as the Constitution drafting authority. It would enact a constitution for the new state, but at the same time, it would exercise ordinary legislative powers. Now, there was, as you might expect, for a country that was just being founded and had just emerged from a war, there was a lot of disagreement about what should be included in the constitution. There was even disagreement about whether there should be a written constitution. The first Prime Minister of Israel, David Ben-Gurion, didn't think it was a good idea to have a written constitution. He thought the system should evolve more organically and couldn't all be set down on paper. So in 1950, they came to a sort of agreement to agree later. It was called the Harari decision. The Knesset resolved that the constitution would be adopted incrementally, bit by bit, piece by piece over the years. And over the next couple of decades, there were 9 what were called basic laws to be passed by the Knesset. And these were all passed just by a simple legislative majority. There was no special procedure, no referenda, no special majorities. But these were not really treated as constitutional laws. It wasn't in the early case law of the Supreme Court. There was no notion that these basic laws superseded ordinary laws or that they were entrenched in any way. Although some of them did include entrenched provisions, and in the case of Bergman, a Minister for Finance, those that got a little bit complicated, and we don't have time to go into that now. But things changed in the 1990s. In the 1990s, Israel had quite an activist Supreme Court. And with the passing of the 9th Basic Law, the Basic Law, Human Dignity and Liberty, which was essentially a statutory Bill of Rights, the justices of the Supreme Court sort of seized the moment. And in the case of United Mizrahi Bank and Migdal Cooperative Village, which is usually just called the Mizrahi Bank case, they essentially converted this statutory Bill of Rights into a constitutional Bill of Rights. By an 8-1 majority, the court, presided over by Aharon Barak, ruled that the basic laws have a binding supra-legislative constitutional status and that inconsistent regular laws are invalid. And President Barak called this the constitutional revolution, and it was quite a turning point in Israeli constitutional law. But following the Mizrahi Bank case, there were some unanswered questions. We had this strange situation where basic laws supersede ordinary laws. They have what you might call normative supremacy. They prevail over inconsistent ordinary laws. But at the same time, they're not entrenched. They could be adopted, they could be amended, they could be repealed just by an ordinary Knesset majority, 61 votes, or even fewer if there are less members actually present in the Knesset. And some of the basic laws had entrenchment provisions requiring absolute majorities, special majorities, or even a referendum in some cases. But overwhelmingly, the basic laws are not entrenched. So it left these 2 interesting questions. Firstly, was there any legal limit to the Knesset's power to pass basic laws? And can the High Court of Justice review the validity of basic laws? It can review the validity of ordinary legislation against the Constitution. It could review the legality of ordinary laws against the basic laws. Could it review the legality of basic laws? And if it could, what would it review them against? So this was an interesting question of Israeli constitutional law. And there were some tentative answers over the years. So there's the Law Movement case where President Barak said that theoretically, there is a possibility that a court in a democracy would declare the invalidity of a law that violates basic principles of the legal system, even if these are not entrenched in a rigid constitution. But that was sort of just a statement in obiter, and it didn't go anywhere. And by 2016, with the Jabarin case, where Justice Chayut, who later became president of the court, sort of ruled it out. She said it's premature to develop any doctrine of unconstitutional amendments, any idea of the court having oversight over the making of the Constitution, while the Constitution's still a work in progress. In other countries like India, we'd seen the courts develop this doctrine of unconstitutional constitutional amendments, but that was in the context of a codified complete constitution, which Israel just didn't have and still doesn't have. But then we had this sort of groundbreaking case of Chasson and Knesset in 2018. And this concerned a challenge to a new basic law that was passed in 2018. It was a controversial basic law. It's often called the nation state. Basic Law. Its full name is the Israel, the Nation State of the Jewish People Basic Law. And its purpose was sort of to introduce more Jewish elements, because Israel is meant to be a Jewish and democratic state. And all the previous basic laws had dealt with the democratic side, and this was meant to even the score a little and give it more of a Jewish character. And in that case, President Chayot, sorry, she wasn't president then, she made an interesting statement, which was that the Jewish and democratic character of Israel is entrenched even against basic laws. So a basic law, if the Knesset tried to pass a basic law which undermined the Jewish or the democratic character of Israel, the court might have the power to strike that down. It might be said to lack the power to do that. And that kind of sat there for a while. But then things really heated up at the end of 2022. A new right-wing coalition government was sworn in after quite a long period of political instability. They had about, I think, 5 elections over the previous 4 years. And Israel has a notoriously fractured political environment. And the incoming Justice Minister, Yariv Levin, put forward a draft bill for judicial reforms. And these reforms were very controversial. A lot of Israelis see, for better or worse, see the Supreme Court as a liberal left-wing institution, as in it's seen as a defender of human rights against a very centralized majoritarian political system. And so these changes that dealt with things like judicial appointments and even more controversially, making it almost impossible for the Supreme Court to invalidate laws, allowing the Knesset a majority override of judicial review decisions, and abolishing the reasonableness doctrine, which I'll talk a bit more about in a moment. It led to these sort of massive protests across the country, the biggest protests that had ever been seen. And they were somewhat successful, you might say, because of those judicial reforms, the only one that was eventually adopted was this, the 2023 amendment to the Basic Law of the Judiciary, which read, notwithstanding what is stated in this basic law, a holder of judicial authority under law, including the Supreme Court sitting as the High Court of Justice, shall not address the reasonableness of a decision by the government, the Prime Minister, or a government minister, and will not issue an order in such a manner. So to understand this, we have to understand a bit about the reasonableness doctrine, but I guess I don't have time to go into that. But what we can say is that this decision was challenged in the Supreme Court, in the High Court of Justice, and in a sort of groundbreaking decision, the High Court ruled on 2 questions. The first was, did it have jurisdiction to review the validity of a basic law? And by an enormous majority, a 13-2 majority, it ruled that it did have that power. President Chayot said that the Knesset's power is not unlimited, and it is not authorized to enact a basic law that denies or directly contradicts the core character of the State of Israel as a Jewish and democratic state. And she drew in elements of the Constitution, going right back to what she called the earliest days of the state, and including the Declaration of Independence, the basic laws, legislation, and case law. And of course, there were 2 dissenting judges, and one of them, Justice Mintz, was very skeptical of this. He said that there's just no constitutional basis for this, and it undermines the sovereignty of the people. It undermines Israeli democracy for the High Court of Justice to be invalidating basic laws. The next question they had to rule on was whether the amendment was actually unconstitutional, and they came to this was a much narrower majority. There was only an 8-7 majority in favor of striking down this law on the ground that it violated fundamental principles of the Constitution and was invalid. Now, in reaching their decisions, the judges had to interpret what this amendment actually meant. And some of them gave it a broad interpretation, and they And according to that interpretation, this amendment actually had an enormous impact on the ability of the courts to review ministerial actions. Justice Grosskopf used this sort of hyperbolic language, you might say. He said it inflicted mortal harm to the principle of the rule of law by effectively exempting those at the head of the executive branch from judicial review and thus placing the government above the law. So Justice Grosskopf and 7 other justices thought that this went against the most fundamental principles of the Israeli constitution. Other judges were willing to interpret it more narrowly. They said it didn't uproot judicial review, and it just narrowed the basis on which it could be conducted. Now, this is a pretty significant decision. What the court has decided is that the Knesset's power is not unlimited. It's subject to fundamental constitutional principles arising from sources outside the constitution. And it seems that in the case of Israel, parliamentary sovereignty has given way to constitutional supremacy. The constitution is supreme over the Knesset. And my question is, could the same thing happen in other countries, the United Kingdom and New Zealand? And we'll have to watch that space. So that's the end of my presentation. Thank you.
Thank you, Marcel, for that fascinating discussion, which delved into the tensions within Israeli constitutionalism. All right, we have about 8 minutes for questions. So we have a question in the chat from Marianne, and apologies if I pronounced that incorrectly. It says, thanks for organising this. I wanted to ask any of the panelists, what direction do you foresee for constitutions going forward? Unstable constitutionalism is a global issue. Is there a way to fix this? Or is the tendency for instability to grow? So that's for anyone to take a response to.
Well, I thought the referee was going to take this one.
I thought Renato going to take this one.
Well, I think that's a really hard question. That's why no one wants to answer it. But I think the tendency will continue. I think stability will continue to grow. I think that's just the zeitgeist of constitutionalism, really. So I don't see any solution, or easy solution at least, in the foreseeable future. I do think that reflection and just social cohesion and how people actually understand their constitution and their participation in society beyond what constitution says, and that what I mean by that is just as part of civil society, as the values that you believe you should uphold in society. I think these are core to whatever change you can have in a constitution in society generally. We can't depend on just constitutions, thinking here in terms of written constitutions, to change so that society will follow suit. I think it starts with social practices and values, and then from there we can think of a way forward. But answering objectively, I can't see any particular change in the foreseeable future, no.
To add a little bit, for me, especially from the third world countries view, what third world countries and what, if I include like myself in them, is to aspiring to have constitutional instability of Western world, right? So we know we cannot achieve constitutional instability, but we want to achieve constitutional instability with less damage, like constitutional instability, but with less war, maybe less human casualty, less chaos. But especially from third world countries' perspective, constitutional instability is in the system is almost impossible. So when I contemplate about this, the way the West or the Europeans solved about its history, like by going through a lot of war, a lot of blood, a lot of like really difficult period. I don't want that. I don't want like Africa and the third world countries to go through that process to at least get into some sort of stable constitutional mechanism. Maybe sometimes what I want to say is maybe if like at least if let's say countries like America with carrots, with force and with money, if they can do something around the political elites of countries like in Africa and in Asia and in some parts of the world, that might reduce the level of instability, but not get rid of instability.
Thanks, Renato and Terafay. There's a further question in the chat for Marcel. Do you know if there have been any further cases to tease out the consequences of that key decision from 2022 in Israel? Has the Supreme Court continued to review for reasonableness for decisions of the executive more recently?
Thanks for the question, Kent. That's a good question. Look, as far as I'm aware, there haven't been any new developments on this front, any major new developments on this front. I think the Supreme Court was, I think they sort of seized the opportunity to make this decision at a time when the Israeli government's not really in a position to push the envelope on this. The decision was handed down on the 1st of January this year, which is at a time when Israel's in a state of war. The government is in a very weak position. There's a lot of discontent. There's a lot of tension between the different coalition parties in the Israeli government. I think they're not really in any position to try and pass another basic law that might be struck down or to reject the High Court of Justice's decision. The High Court of Justice has continued to review the reasonableness of cases. They haven't departed from their doctrine of reasonableness in any cases this year. And on top of that, they've continued to like an example of that is the recent decision to force the government to draft ultra-Orthodox Jews into the IDF, which is a hugely controversial decision and one that's caused a lot of consternation amongst the coalition partners in the government. So the High Court of Justice hasn't backed down. We'll have to wait and see what happens in the future.
Thanks, Marcel. We are pretty much out of time. I'd like to just thank again Marcel, Renato, and Terafay for your presentations. I think there's a common thread which brings your work together, which is about the kind of the function of constitutions and what are they for? How can constitutions be framed in order to achieve whatever their aims are? And their aims may well be different in different societies with different democratic and constitutional contexts. And then what's the relationship, or in some cases, the tension between constitutionalism and democracy? There's been scholarship out recently critiquing the very idea of constitutionalism itself and its relationship with democracy. So I think there's a lot to watch in this space. Thank you both very much. And thank you everyone for participating. I think Peter wanted to just say some final words before we finish off.
Yeah, thank you so much, Alex. I just wanted to add my thanks just on behalf of the Queensland chapter of the Australian Association of Constitutional Law. Thank you to our three speakers for fascinating papers, a lot to think about. And I also just wanted to thank Associate Professor Alex Deegan as well for agreeing to chair this event and for doing such a great job. And thanks to all the audience for coming along as well.
Thank you, everyone.
Have a great night. Thank you.
Thank you very much. Thank you.
Thank you.
Thank you.
Thank you.